Ah, tá. Ah, ok. Não, só vou. É, só falar, só voz, só voz. Tá. Tá. Se ficar muito alto, eu acho melhor. Eu acho que já é melhor abaixar um pouco, talvez, não. Mas enfim, vocês. É. Tá. Beleza. Obrigado. Não precisa entrar aqui no. Não precisa clicar aqui não, né? Nessa telinha aqui de. É só seguir o. Já entra automático. Já tá. Tá. Eu acho que estão escrevendo aí, então talvez não precise. 4. 4.
Good morning, everyone. We're going to begin our panel. If you could please shut the door. Thank you. Good morning, everyone. We will begin panel 2 about compulsory licensing in the post-COVID world. I'm going to be brief in my introduction so that we have enough time for a Q&A session at the end. Just some context about this topic. As you know, in the beginning, in the onset of COVID-19 in early 2020, compulsory licensing and this topic had a lot of highlight in the media in terms of intellectual property and also in specialized for both here in Brazil and internationally as well. From an international perspective, I would like to mention the WTO and the EU. For the WTO, as you probably know, South Africa and India presented a proposal in late 2020 of a waiver of obligations foreseen on the TRIPS agreement regarding IP, and the proposal talked about a waiver of any IP regarding prevention and fighting COVID-19. A broad proposal. If it is accepted the way it was presented, it would have extreme impacts, more extreme even than a compulsory license. After a lot of debate at the WTO in June this year, after 1 year and a half of heated debates, WTO presented its decision without establishing any type of waiver or restriction regarding intellectual property rights. It's a decision that actually clarifies what was already foreseen in the TRIPS agreement. It clarifies compulsory licensing and how it should be applied. Regarding the EU, earlier this year, the European Commission, which is the executive body, started an initiative to study compulsory license in the 27 member countries. Dr. Janssen's going to discuss this in a minute, but the idea is to present a legislative proposal to find a balance between all member states. And Mr. Janssen is going to discuss this in his presentation. Bringing this to the Brazilian reality, compulsory license, as you all know, is foreseen in our legal structure since 1996. But still, last year, as we saw in the media, Act 14200 was passed, and it has some alterations in the intellectual property legislation regulating compulsory license in Brazil. So this is a topic that has been the subject of heated debate since early 2020. It's a difficult matter because it involves legal, economic, social, and even political matters, all interconnected. And our goal with this panel, of course, it's not to exhaust this topic, but to present 3 different perspectives according to the areas of activity of our speakers. We will have Dr. Ana Carolina Cagnoni. She will be the first speaker. Ana Carolina Cagnoni. She's a lawyer, and she's a director of IP at Interpharma. She has a degree from the University of São Paulo and a master's at Queen Mary University. Then we're going to have Bernd Janssen with an European perspective about this topic. He's a German lawyer and he works with patents. He's a partner at Hochschule Stolberg. He has a background in chemistry from the University of Heidelberg. And finally, bringing us a legal perspective, we have Judge Caroline Tauk, a federal judge from the Second Region Court, and she specializes in IP. She has a master's in public law from the State University of Rio de Janeiro, and she was a visiting scholar at the University of Columbia in New York. Just a brief version of their CVs, and we have their full CVs available in the website of our Congress. So I now give the floor to Ms. Cagnoni to begin the discussion. The first speaker always has this difficulty. We don't know where to look. But anyway, good morning, everyone. It is a pleasure to be here at the ABPI Congress. This is the first in-person Congress after the pandemic. Quite an interesting recovery moment. Going back to our previous life as it was before 2020. And this panel is very much connected to what we've gone through and what we will see moving forward. Can I have my slides on the screen, please? In any case, I wanted to thank Felipe Bering for inviting me and also the other members of this panel to have an in-depth perspective about compulsory licensing. So my presentation is divided as to cover specifically this moment of the pandemic. My intention is to cover compulsory license in Brazil before 2020 and compulsory license, how this was debated, or maybe the lack of a critical debate about compulsory license throughout the pandemic, what were its impacts, and where do we stand now? So before the pandemic hit, well, and let's remember that it began in December 2019 in China, and it reached Brazil in early 2020. Compulsory license, I know this, I'm talking to experts here, but in any case, it's important to go back to this timeline. Compulsory license was already established in our intellectual property legislation in Section 3, Article 68 to 73. Compulsory licensing is an exception established for the patent regime. Most people might, or the lay population might think that this is just for national and public interest cases. That's Article 71. But actually, compulsory licensing is an exception that can be used by the state in different situations, such as economic power abuse, where we find a correlation with free competition legislation. So the antitrust entity in Brazil can use this mechanism when there's a lot of economic power concentration or when there is an abuse of economic power. So compulsory license can be evoked in these situations, and also when there is a patent granted, but it is not being explored in Brazil, or when the Brazilian market is not being fulfilled or met. But these situations are rarely remembered. People have the feeling that a compulsory license is only possible in an emergency and public interest context. But it's not exactly like that. So when we read Article 71 before, Compulsory license was already established in our legislation for over 25 years in national emergency or public interest situations. So it should be temporary and non-excludent or non-exclusive. That's what the legislation established. It is important to highlight, or going back to the fact that compulsory licensing is not segmented into one specific economic industry or to a specific group of technologies. Compulsory licensing can be granted for any patent whatsoever, a mechanic, electronic, chemical, pharmaceutical patent as well. And sometimes people have this idea that breaking a patent would only be possible in a public health emergency concerning drugs. So now let's look at the pandemic and what happened. Well, there was legislation moved by the Congress, quite intense regarding compulsory license, and they worked fast. In Brazil, in February 2020, we had legislation 1320, which established a health emergency state because of the COVID-19 pandemic. You probably remember that the first surges regarding COVID, they began in December 2019 in China. They reached Europe in winter that year, and they reached Brazil around Carnival in February 2020. We remember when we started buying face masks and hand sanitizer, right? It was very early on. We knew nothing almost about the virus, but in March 2020, we already had a bill regarding compulsory license being studied by our Congress. And it was very early in our debate about the subject. Everything was very much new, but some legislators had the understanding that it was important to discuss this topic. The two first bills that came in the lower house regarding compulsory license, as we see in this slide, I'm not expecting you to read this, of course, but there was a lot of what we had in Article 71 of the existing legislation. Again, temporary and non-exclusive. So the bills were, in a way, repeating what the existing legislation already stated. But the goal was to have the topic being debated and to put this theme under the spotlight. So the legislators were showing their interest in solving or facing the pandemic. Maybe because of a lack of knowledge of legislators. But the fact is that the bills didn't bring anything different from what the legislation already stated. So it makes us wonder how much room there is to improve this debate in the public sector, and how can we improve the dialogue about compulsory licensing. Having a bill that brings nothing new to the table, it might get the population confused. People will have an expectation regarding something that was already established by the existing legislation. At that point, it was not possible, however, because we didn't have any products connected to the pandemic. Then we had Bill 1184, again, speaking on the same terms, temporary and non-exclusive. And there were other 15 bills in Congress. Interpharma is in constant connection with international institutions, and Brazil was by far the country that had more debate, legislative debate about compulsory licensing, when actually our legislation already established this mechanism. In this table, we have mapped what happened until June 2021. So we see 5 bills plus 12 bills which were attached to the other 5 because they were connected to the main ones. Legislative movement, as I said, whether because of a lack of knowledge or due to electoral purposes, searching for solutions that actually already existed, we saw this move, and Brazil had more discussion on that matter than other countries. The impact of that debate is that Bill number 12, written by Congressman Paulo Paim, it moved faster because this bill did not repeat the existing legislation. It actually had alterations connected to Article 71 from the existing legislation, and it was passed. At the time, ABPI and these other organizations, we wrote an open letter against this bill, Bill 12. That was the second semester of 2020. The first approved vaccine globally for COVID-19, it was approved in the US in December 2020. So this legislative movement happened before that. And these associations, which you see on the screen, they took a stance against this bill because of 2 things. First, it repeated the existing legislation and it removed the focus from what was important in the discussion for all stakeholders to discuss more urgent and important measures. And also, the bill brought additional aspects, and in our opinion, this extrapolated reasonable boundaries of the compulsory licensing mechanism. And therefore, Brazil could have a legislation that would be questionable and maybe far removed from international standards. Well, in spite of this open letter and these movements, Bill number 12 moved forward both in the lower and upper houses of Congress. So it was passed by the Senate in April 2021. The speaker corrects herself. And in the lower house, it was passed in June 2021. The bill then was ratified by the Senate, and it was approved by the president in I don't remember exactly the month, but I believe it's September 2021. The clicker doesn't seem to work. So in less than a year, we had the 2 houses of Congress looking at this bill, some presidential vetoes. So we are looking at a period between April and June 21. The vetoes focused on 3 aspects that were correct, in our opinion, because they exceeded the subject of compulsory licensing, going beyond what we believe is reasonable. And also regarding the fact that it should be put into practice. We had an absolutely fast legislative approach connected to a technical subject. Most lawmakers have no technical knowledge of this, and there was no possibility for debate or reflection. Of course, it was a pandemic context. many bills being published. We had online public hearings and many difficulties, but it's such a technical topic. And I believe we could have had more room for discussion. So Bill number 12 changed Article 71 from the existing legislation. It expanded the possibility of compulsory licensing for international emergency cases, which sounds a little bit questionable, the need to flexibilize patent rights due to international matters. Also, for those experts in the audience, the issuing of compulsory licensing regarding requests for patents. So these are patents that have not been granted, and they might not be granted. So that might cause some confusion regarding what is a patent, in fact. There is this possibility also of the state having to provide a list of what events regarding patents could be used within 30 days, which is a very short deadline to assess an emergency scenario and list the patents that should be the focus of compulsory licensing. And the legislation does not state who should create the list. Is this a ministry? Is this the National Intellectual Property Institute? Who should be responsible for this? It's not clear. Any private or public organization, for profit or not for profit, can include patents in this list for compulsory license. And if you want to exclude your request for a patent, it's difficult to discuss this when it's just a request for a patent. But you would have to negotiate a technology transfer contract with the government, or you might need transparent contract. So you would have to disclose on confidential terms of the contract if you want it to be removed from the list. And also a fixed compensation of 1.5% over the net price of the sale. That's what's in the legislation, because this bill was passed and it's now legislation 14200. Many of these aspects that I list here on the screen, in my opinion, I believe that Brazil is being innovative in terms of patent legislation, and it's going to be interesting to hear what other panelists will say about this. This bill also included Article 71A. It is a sector-specific article just for pharmaceutical industries. It states that Brazil can issue compulsory licensing for exports in humanitarian crisis situations. This was already included somehow in the TRIPS agreement or in the Doha Declaration, so this is not innovative in itself. Moving to the end of my presentation regarding the vetoes. Bill number 12 had vetoes. It was vetoed. It was passed by the majority of our Congress. All parties agreed on this because there was an emotional appeal. Legislators and the population in general had this belief, and I believe it's important to talk about this. There was a belief that this could solve the pandemic. We knew it was not the case. This was not the case. A pandemic would not be solved with compulsory license. Brazil faced the pandemic with voluntary agreements between international and public laboratories. Laboratories that hold the technologies and also private laboratories. It seems clear to me that it's more advantageous and beneficial when you try to do this voluntarily, reaching an agreement and having clear negotiations. Well, going back to the veto, these are points that extrapolate compulsory license, in my opinion. So mandatory technology transfer, paragraphs 8 and 9 of the bill, that stated in a situation of compulsory licensing, this would be open to third parties. So the description of the patent as it had been requested would be open to third parties, and the holder would have to provide test results and other necessary data so that the subject of the patent could be reproduced. I believe this extrapolates the social agreement regarding a patent. There is a business secrecy involved here. There is something that the holder of the patent does not want to disclose. And authorities accept that. So this goes beyond what was agreed. And therefore, it seems to me excessive, innovative, when we compare to other countries' legislation. This was vetoed, and the veto was held in June this year. There was a veto also against compulsory licensing by the National Congress, which is not very efficient from an operational perspective. There was not clarity. Would you need a bill to go through both houses to obtain a compulsory licensing? So from an operational perspective, this mechanism could not even respond to a necessity. So in my opinion, this was more the result of a political dispute we were looking at between the Congress and the executive branch. In practical terms, this would lead Brazil to have a legislation that would not be very much effective regarding compulsory licensing. So the vetoes were held, as I mentioned, and this is the legislative context we have right now. There was no intention from the Brazilian Congress or the National Congress to issue a compulsory licensing throughout the last 2 years of the pandemic. So we did see this legislative moves disconnected from the reality or from the facts. The Congress made a move to change an existing regulation, a regulation that was very much in line with international standards, and they brought in a more complex legislation that is more difficult to interpret somehow. And there's no practical need for the new legislation. The government has never tried to attempt compulsory licensings. Brazil worked throughout the pandemic with voluntary licensing and was successful in that sense. When we look at vaccination figures and statistics, we see that clearly. Just to finalize, and I am available for questions later on, but I think that compulsory licensing is an exception mechanism. It cannot be the rule, and it cannot be used as something that you use whenever you have an emergency. And compulsory licensing does not necessarily lead to a decrease in prices. We see this in other countries. Compulsory licensing does not necessarily improve the availability of drugs. So a specific drug for a specific disease will not necessarily become more available through compulsory licensing. So there's caution in making these products available because that might be subject to compulsory licensing. So depending on the situation, Countries that issue compulsory licensing, they receive oftentimes outdated technologies. And these technologies arrive later, or oftentimes they don't come at all. So you might actually hinder the possibility of a volunteer license because there is uncertainty from stakeholders when negotiating with a government that out of nowhere might try to have a mandatory move. It does not necessarily develop local production. Brazil is a case in point. It took a while for Brazil to produce a drug that was licensed in 2017. And when we look at the global context, countries that have developed an international market for the production of generic drugs, they work quite strongly in that sense. So if compulsory license has the goal of developing the industries, the country's industries, will that actually happen? Or maybe will that just lead to imports from other countries? It's important to take that into account. Also, compulsory licensing does not solve systemic barriers to access to drugs. When we reached record levels of production, the difficulty was in storage systems and logistics or distribution, health professionals that were trained to deal with that. So that type of barrier is not solved by compulsory licensing. When you don't have enough refrigerators to store the drugs, or when you don't have enough skilled workers. So these are just some reflections regarding the health industry. Compulsory licensing, of course, is not just for the pharmaceutical industry. And that's the end of my presentation. I'm available for any questions you might have. Thank you.
Dr. Ana Carolina, switching over to Dr. Byrne, I just would like to point out the summary of your comments. This is a complex matter. It requires technical skills. You refer to the bill that was introduced in early 2020 at the start of the pandemic. And I wanted to say something else. Well, another highlight is that compulsory license is not necessarily translate into making drugs readily available to the public. The only example we have between the license and the production took about 2 years. This isn't often clearly explained. I'll turn over to Dr. Byrne now. Thank you, Felipe. Thank you for having me. I was invited to talk about the latest developments of compulsory license in the EU. They were introduced because of COVID-19, but basically by the community system. It does not have a rule specific for compulsory licenses. Something that can be developed within the European legal framework. These are up to national legislation. In late March, the European Commission published this invitation to participate in an impact assessment of legislative proposals. And that assessment is scheduled to be concluded in the first quarter of next year. The goal is to harmonize all these laws. What would be an impact assessment? These initiatives are supposed to have economic impact, social or environmental impacts as well. So these representatives, as well as citizens, are supposed to present their points of view about the proposal. As soon as that proposal and the impact assessment is published, citizens and other stakeholders will once again have a chance to comment on that proposal. So we are still at an early stage of that process. There are several pieces of information worth studying. It's been described here in this proposal, this type of information. This invitation states that intangible assets, such as patents, are the main pillars of the economy. Patents are key to support EU because they affect investment decisions. This is very important. They impact investment decisions at every industry level. This is one of the most important tools to determine industrial policies within the European Union framework. Despite the strategic importance of patents, the rights to patents remains fragmented. And why is that? Despite the introduction of the single patent system, several of these issues are still discussed within the national courts. For example, the regulation of the reinforcement partnership of unit production. That considers that mandatory licenses of European patents for the entire Union should be regulated by member states, whatever is related to their own territory. This is within the regulation. So the legislation is fragmented, but there's a reason explaining that. There's no compulsory license provisions in that European regulation system. This system is appropriate for the time being. This will enable access to critical technology. There are several implications that we're about to dive into. The pandemic highlighted the need for a strong intellectual property system to develop new forms of treatment and vaccines. At the same time, it states that we need appropriate structure to gather information, technologies, and know-how, just like in Brazil. Public cooperation based on voluntary decisions to share IP, such as licensing agreements, is the most effective and the quickest way to boost the production of drugs. The rights of third parties, if that agreement fails, we may resort to the compulsory licensing rather. This is identified as a last resort measure. And why should it be considered as such? We're talking about intellectual property. Compulsory license, at times, can be regarded as an innovation equivalent to expropriation. You can only resort to that measure if you have grounds to do so. The way the Commission sees it, it shouldn't be limited to the pharmaceutical industry. However, all other technologies that are deemed as critical technologies should be included, and they refer to green and digital technologies as well. If we were to limit to the pharmaceutical industry, we wouldn't need that initiative because we already have a regulation specific for the pharmaceutical industry. It's the 816 of 2006. They include patents for pharmaceutical products for exports for countries that have some public health issues. If you want to manufacture products that are needed in these countries facing health issues, that can be granted according to this regulation. There are some restrictions, however. You have to report as to the volumes of exports to prevent the re-importation of these products. So this regulation establishes a standardized application of that decision to make sure that the concession of compulsory licenses are the same for all member states. There are uniform rules so that countries do not re-import these products, products manufactured according to this regulation. This initiative aims at realigning the patent standards so that we can promote the digital transformation within the European Union. However, promoting technical knowledge through patents, we can include access to critical technology. So the objective of this initiative is not that clear. The goal is to promote the green and the digital transformation to make access more available so that we can have a proper admission of these initiatives during crises. And there are several negative criticism. There is negative criticism for this target. In Germany, for example, crises are addressed very differently from the legal standpoints. And I'm referring to overall access to critical technologies. And these scenarios are dealt with differently within other national legislations. Article 13 of the patents law in Germany determines how the government would intervene during crises. Patents do not promote effects. If the government states that that patent is to be used in the interest of the federal government and the public well-being, patent holders are entitled to have some reasonable compensation from the government. That cannot be transferred to the European Union, however. This should be dealt with within the national legal framework. We also have Article 24. This is in Germany. That's the regulation of compulsory license. The exclusive right is granted on a case-by-case basis. Those that require the patent looked for other sources for a reasonable period of time. They have to request that grant to use that. And then if it's according to the public interest, compulsory license is to be granted. It's not paid for by the government. It's paid for by the requirer. That makes a huge difference. The beneficiary of a license according to the Article 24, that's a company willing to license that patent, and the court will determine whether those requirements are met or not. We do have compulsory license based on competitions law. It shouldn't be discriminatory. It will be discussed on panel 10 with other speakers. This is a whole different matter. But that initiative would like to regulate those parameters too. Because that would be included in their goal, which is to make access more available. The Commission would like to ensure that the European Union, and not companies, should regulate these technologies, which are critical: pharmaceutical, digital, and green technology. that would require another regulation framework apart from the classical compulsory license regulation. It can be compared to expropriation. That is very critical indeed, since this should be used only in special conditions. It should be regarded as a last resort. On the other hand, the goals of patents to promote technical advances wouldn't be achieved. This initiative addresses key issues about the future of patents. The first goal is to harmonize differences that there are as far as the protection of patents go, such as compulsory licenses. But there's another initiative to standardize the supplementary certificates for production. And they should be harmonized, such as European Union patents. But that harmonization was not achieved during the negotiation. That was excluded from that negotiation. The patent systems is an incentive to promote innovation, and that license should not get in the way of hurting the creation of new patents, and should be regarded as the last resort mechanism, as we said. Back in 2017, there was a court decision in Germany that ensured the first compulsory license. It was approved by the higher courts in Germany as well. The patent was very weak and its viability was not clearly determined. There was serious decision. Public interest was approved because that drug was unique for pregnant women with heart condition. So that license was granted back in 2017. But only temporarily. The patent was canceled then, and they had to pay for it. So during that period, they were supposed to pay for their license. This is the latest developments, or these are the latest developments from Germany and from the European Union. Thank you for bearing with me. And just like that famous song, I'm sorry for my bad Portuguese.
Thank you. It's very interesting to hear an European and German perspective. As you mentioned, this is a last resort. It can compromise on innovation. And now I give the floor to Caroline Tauk, please. Good afternoon, everyone. Good afternoon. Thank you for the invitation. It is a pleasure to be here with you. I've met some of you online, and it's a pleasure to see you again. I'm going to talk about compulsory license regarding the Brazilian context and changes in legislation. Carolina has already covered a little bit of ground. I'm going to speak about some pros and cons regarding this change in the legislation and the possibility that this could be taken to courts. There's an article also published in Nature magazine that talks about the complexity of patents when it comes to vaccines, which I think it's important for a compulsory licensing perspective. I always like to say that intellectual property is one of the incentives for innovation. It's a way to compensate those who create this innovation. Compulsory licensing exists for exceptional situations that justify the looking at the law of exclusivity or the right to exclusivity. Just like Mr. Janssen just said, compulsory license is a last resort. There are other ways of avoiding its use. We have voluntary license or the sharing of technologies, and the UN, or actually the WHO, is pushing the access to vaccines for developing countries, but this has nothing to do with compulsory license. These are short-term solutions that are more efficient than compulsory licensing. But of course, that is a possibility. It is established internationally in the TRIPS agreement, as we all know, and this is not specific for the pharmaceutical industry. Regarding the health industry, we have the Doha Declaration that fosters this concern with the health industry, especially with developing countries and their health industry. Well, speaking of the change in the existing legislation, now we have legislation 14200. As Carolina mentioned, there was some legislative change brought by the pandemic. Of course, the pandemic had an impact in that. I highlight here the differences in the two pieces of legislation. National emergency is now added by an international emergency. As Carolina mentioned, it's difficult to see whether this is going to have an impact in Brazil or when we are going to have to grant these licenses. It also states that it has to be focused on public interest declared through a piece of legislation connected to a public emergency. And it also includes not just the patent, but requests for patents as well. All other aspects of the previous legislation were preserved. In Brazil, as you know, we had compulsory licensing declared for efavirenz because our country was facing difficulties in finding good prices for our country. Merck was not giving us better prices, and that's how we stated a compulsory licensing. So we actually imported different versions of this drug, and it's important to highlight that the efavirenz decree decree was important because it had an influence in legislators when changing the existing law. This shows clearly what was the inspiration to change legislation 14200. The patent request can already be granted. And again, as Carolina said, maybe the patent is not even going to be granted at the end of the process. So we would compensate the holder of the patent even before the patent is granted. Well, and what if it isn't granted? What do we do with the compensation that was already paid? There is a list of patents or requests foreseen in the list as soon as a national emergency is stated. And legislators state that the compulsory license is the last resort, only to be used when other mechanisms such as technology transfer or volunteering licensing are exhausted. So the compulsory license is a last resort. And finally, it makes clear that compulsory license can only be granted for companies with the technical and economical skills, uh, and that can be a hurdle to compulsory licensing in Brazil. The new legislation also states or says that public institutions have to share information and data they obtain. So they have to share all elements. It has to reproduce the licensed object. And this is regarding tests or the results of tests that are registered. So these institutions have to share those. And one cannot argue that there's unloyal competition when these test results are shared. The new legislation excludes this possibility of unloyal competition. That is inspired by the Efavirenz decree, which also states the possibility of sharing. And also it establishes a fixed compensation. And that possibility should raise an alert because the conditions for licensing are variable. They can vary. And although they can vary, compensation is fixed for all of these cases. Again, there is an impact of the Efavirenz decree, which stated also a fixed compensation of 1.5% regarding the price of the drug. So this was the only case of compulsory license we've had in Brazil. After this initial context about the change in the legislation, I would like to give some pros regarding this change in the legislation as a way to improve compulsory license in Brazil. This is a worldwide movement. It took place in Chile, in the Equator. We've had the same movement in Canada and also in Germany. In our Brazilian debate, there was a technical opinion published by the lower house of Congress. It was published before the bill went for a vote, and it made clear that legislators were concerned about finding favorable arguments regarding this proposal. And they said that some laboratory researchers received public funding, large volumes of public funding. That's why IP should be shared, even if there was no such agreement when the labs received funding, public funding for their work. So this is an argument that was present not just in Brazil, but around the world as well. And what we see, the blue dots here, this is public funding. Green is private funding. So for Moderna, we see a lot of public funding. Novavax, CureVac, we see a large share of public funding for these developments. So we see a clear presence there is a clear presence of public funding in the development of several vaccines. And this is an argument that was used in worldwide debates. I'm not taking a personal stance here. I'm just showing you what was present in the debate. So again, public funding and innovation regarding legislation for compulsory licensing. What are the cons regarding compulsory license? Well, first, the possibility of granting a compulsory license for a patent of a vaccine in Brazil, it would take a long period of time because the National Intellectual Property Institute has a long deadline to analyze these requests. So that would take a long period of time in Brazil. So we would face compulsory licensing requests or compulsory license for requests of patents in Brazil. And this was already debated by the previous speaker. Also, there's an operational difficulty in putting this mechanism to practice before vaccines reach the end consumers. So they need technical and productive capacity to explore the patent. And when we look at the technical capacities, when the compulsory licensing of efavirenz took place, Brazil did not have skilled labor or expertise to produce this drug within our boundaries. And that is why compulsory licensing was granted. This allowed our country to import this drug from other countries. That's what happened. Efavirenz was imported from laboratories in India so that the drug would be distributed in our public health system in Brazil. If we look at our current technical production capacity, when we look at Butantan and Fiocruz institutes, these are the two labs that are currently producing vaccines. They are operating at full capacity. Is there idle capacity for them to produce a different vaccine if there were to be a compulsory licensing? We currently don't have, in the private initiative, labs with the required expertise that could produce vaccines, neither the inputs. So when we think about the possibility of a compulsory licensing for vaccines, if we think of Butantan and Fiocruz institutes, this was focused on CoronaVac and AstraZeneca vaccines. They received the expertise for those vaccines, but not for all existing vaccines. So that adds an additional difficulty for the production of vaccines by these laboratories. So I've brought some pros and cons regarding compulsory licensing when connected to this change in legislation that took place in Brazil. And this is an article that was published in Nature magazine. It's not about compulsory licensing, but it talks about patents connected to vaccines. I know that you are all waiting for lunchtime, so I'm going to be brief, but I just wanted to mention the article states that the context of IP connected to vaccines, it is more complex than other health technologies or other pharmaceutical technologies. So granting compulsory licenses for vaccines is something that deserves careful attention, more so than with other drugs. And the article states that mRNA vaccines, they have huge complexity, more than other drugs that are available. These are the arguments contained in the article. The technology to develop vaccines is protected by patent, as well as for trade secrets. And these trade secrets are not included in compulsory licenses. And we can only reach vaccines in record time. That's what the magazine states. We've only developed vaccines this fast because there's an intricate relationship between those who invest in research and innovators who place this product in the market so that it reaches consumers. So we needed the technology to develop the vaccine, and that was developed by research startups or labs. And their technology is protected by patents. But after this stage, there is also a license for innovators. These are the large companies that turn a technology into a final product that will reach consumers. The larger colored circles in this slide right here, they represent the main technologies used by these companies. The gray lines that connect the circles, these are the common patents between these products or the licenses that were granted between these companies so that they could become a finished product. So to reach the existing technology, some of these companies have used licenses connected to other companies. And that's the product that reaches consumers. And the smaller, the tiny knots you see around the circles, they represent company patents that were used for them to produce their end product. So it's quite a complex network of patents involved in the production of vaccines. And we don't see this for all drugs. So we need to be especially careful when we talk about compulsory license for vaccines. The article in Nature concludes that the mRNA technologies, they were being developed since 2005, and COVID-19 accelerated this process. So to reach this end result, which is the one we see today, we received efficient vaccines in record time. But this research started in 2005. The article states, if we look at the summary of the patents and of the requests for patents connected to mRNA technologies, we will conclude that they use terms and technologies that are common to this intricate network. And the image shows clearly this interconnection between all these companies so that we could have such an efficient final product. And we have to take this into account when we talk about the compulsory licensing process for vaccines. So summarizing our panel, Compulsory licensings, they're legal. It's a legal mechanism. They are foreseen in the Constitution, but they are designed to be used when other forms of access to technology have been exhausted. And that happens because IP aims at fostering innovation. It's an important incentive to innovation. And research has to continue for new variants, new antigens that might arise. If we need compulsory licensing, of course, we should use it, but there are hurdles. We need to find countries and companies with the right technical capacity to produce the vaccines. Of course, Butantan and Fiocruz worked with excellence, but we saw the difficulty we faced in several countries. And also, this is a very complex patent environment for vaccines, and we have to be aware of that. When we speak of vaccines, we are talking about human lives, and innovations should improve our quality of life. We only protect these things because we are talking about human lives. Looking at all those difficulties, I believe that the most important thing is to reach global solidarity and a joint work between governments, private entities, non-profit organizations to reach results that are beneficial to everyone, including the pharmaceutical industry. Thank you very much for your attention. Thank you for your brilliant presentation, Ms. Talk. And it's important to think about these cases that might reach the courts. So the Favirenz decree, that was 15 years ago, and we saw what happened. It's difficult to think of a fixed compensation for all cases. I know we are over time. I hope we can have a couple of questions from the audience. Just briefly, feel free to ask your questions or make your comments. I have a question for Mr. Janssen. You spoke about the German or the European initiative and the goal of presenting a proposal earlier next year. Is this feasible? Do you think it can actually happen? What's your feeling regarding the timeline established by the European Commission? Well, I believe this is a very bold timeline. We still need many answers. And I think we need a little bit more time. But I do hope we can have a proposal by late next year or early 24. And then the process will follow its course. There will be a timeline for comments and responses. I believe that public hearings have just finished, right? And most comments were in opposition to this proposal, stating that the current system is already enough. Yes, the comments state that this is a national matter, that this should be dealt with according to national legislation. In the COVID pandemic, the measures that were taken such as face masks, they were taken locally. These measures were taken locally. So these are national interest matters. So maybe this proposal might not even come. Well, there's a lot of political pressure, in Germany. They want to harmonize this topic, just like you in Brazil. There's a lot of federal investment to promote vaccines, most with BioNTech, which is a German company. And there is a shared initiative as well. Sure, thank you, Mr. Janssen. Do we have any questions from the audience to our speakers? Please go ahead. Hello. According to what you said regarding compulsory licensing in Brazil, we always speak about the pressures received in Brazil from international players not to grant the licenses. So much so that we've only had one case so far. And whenever we discuss this again, we see international pressure against this. In other countries, how does that work? Is there also this pressure game, or maybe more developed countries have an easier way to deal with this? Thank you for your question. Well, I'm going to give you my feeling, my impression, because we focus a lot in our Brazilian reality. In my experience in the pharmaceutical industry throughout the pandemic, I started looking at IP from a different perspective. IP is an international matter. We see this when we look at figures. And it's not just in Brazil. Most patents filed in the US, they are Chinese patents. So we see a huge international exchange. And therefore, we have this need to harmonize these rules among different nations. In any situation when we have to break a cycle of trust regarding legislation, that will always lead to pressure, no matter the country. We've read news about compulsory license in Israel, and this, of course, destabilizes the trust created by the IP system, which is based on international treaties. So it is a national matter. In the EU, we are looking at this problem. How can the EU decide on something which will be paid by each individual member state? But I think it's up to a global forum, such as the WTO, to discuss all interests present. So it's a very intricate subject, as Caroline mentioned. I don't believe one single country is free from pressure. It can be pressure coming from other countries or pressure coming from global industries. But I think this is expectable when we think about IP rights. It's not just Brazil that is under pressure. Any country that attempts to move away from this international harmonization will face pressures due to the investments that were made. So that is my opinion. When we think about the international movement, this topic was debated in the WTO, and there was this decision made 2 months ago. There was a proposal from India and South Africa of a waiver regarding patent rights, and the decision went the opposite way, just clarifying the flexibility that is already established by the TRIPS agreement. So after this decision, vaccines produced due to compulsory licensing, they can be exported and not just focusing on the national market. So this was a topic, this was the subject of a heated debate in the WTO. If we have no further questions, I believe we should wrap up. We are 30 minutes behind schedule. So thank you, Ana Carolina, Bernd, and Caroline. Thank you for your brilliant presentations that add a lot of knowledge. Thank you all for being here this morning, and see you later.